This is the time set for oral argument in State versus Chantry. Our case, CR19 0427. Counsel, good afternoon. We look forward to oral argument today. Each side has 20 minutes. If appellant wishes to reserve a portion of that time, you're free to do so, although you need to keep track of your own time. And as I indicated before we got started, I will let you know how much time you have left if you do decide to reserve some for rebuttal. We have reviewed the briefs, and there's much to review. We've reviewed the record. We've conferenced the case. We would encourage you to keep that in mind as you present your argument. I will be keeping time using my smartphone, and that's the official time record for today. We would ask when you present oral argument, if you would, given that the proceedings are being recorded, that you would start by telling us your name and the party that you represent. With that, Mr. Barrientos, you may begin.
Good afternoon, Your Honors. Alejandro Barrientos on behalf of defendant Thomas Jonathan Chantry. Your Honors, this case stems from a trial that occurred for conduct alleged that occurred more than 20 years ago, 23 to be exact. In this case, there was no physical evidence. There were no witnesses. The state's case ultimately hinged on the word of one man, and that is 31-year-old MJ. I'd like to just briefly mention a couple of facts that I'd like to keep in mind as I move through the issues. Because I think that they're important and to contextualize some of the things that I'll be saying. So MJ in 1995 told his parents that Tom, our client, then a pastor, was engaging in unjustified disciplinary spankings during his tutorings of MJ. And in 2000, a 16-year-old then MJ wrote a lengthy letter that he characterized as the most complete and separate account of what happened, in which he again accused Tom of excessive disciplinary spankings, as other kids did. Then in 2006, MJ reached out to Tom and he said he wanted to talk to him. Tom finally agreed, so long as there was another person present there, and expressed some remorse, but not enough to MJ's satisfaction, as he noted at trial. And in 2009, MJ sought another apology from Tom, but Tom did not respond. So fast forward to 2016, after years of not obtaining a satisfactory apology, then MJ accused Tom of molestation. That, of course, inherently affected Tom's ability to defend himself at trial for all the reasons described in the statute of limitations cases by this court, Arizona Supreme Court, and the US Supreme Court. And I'll get to that later. But the parties proceeded to trial. So at trial, there's only one witness to the charged conduct, MJ. And then although the state spent days presenting inflammatory evidence of other spankings, at the end of the day, only one witness had knowledge of what occurred in 1995. And although Tom's ability to defend himself is severely impaired because this occurred so long ago, in preparing for his defense, he learns that shortly before all these investigations began, MJ had lied to police. Specifically, Tom learns that MJ lied not once or two times, but 3 different times to law enforcement officers, shortly before these investigations begun. So the unrefuted evidence shows that after being accused of some misconduct by some teenage girls, MJ was approached by officers and he denied it. He denied the conduct on the scene. He denied the conduct in the patrol vehicle. And again, when he was at the police station, before ultimately pleading guilty to that conduct. And then the 2 girls that actually called the police on that day identified MJ on the scene as the person they were accusing. And so does a gentleman who was accompanying the girls and talked to police upon their arrival. So this type of evidence pointing to a specific instant where a person lied is admissible under Rule 608B. But in this case, the court kept it out because it concluded that Tom was wrong in asserting that MJ lied because the plea is not, quote, absolute and indisputable proof that he lied at the onset of the investigation. And then without any evidence, go ahead, Judge Sama.
Counsel, yes, let me ask you, the plea was to indecent exposure, right?
Correct.
It was not to a crime, be it a felony or a misdemeanor, that impinged his, truthfulness, the exception under 609, right? So,
Yeah.
so how there's a little bit of a disconnect in your argument in that respect.
Yes, Your Honor. So he was trial counsel. Tom's trial counsel didn't try to bring in the evidence under a prior felony conviction or the rule that applies to misdemeanors that necessarily implicate dishonesty. He attempted to. He attempted on the multiple rules, and that was one of them. And the court denied it on that. But so the only one that survived was 608B, which does not require a prior it does not require the conduct to be a conviction, number one. It just requires a specific act of untruthfulness. And it cannot be a stab in the dark under this court's case law. It has something that can be identifiable by time and date.
And the court has substantial discretion in that to avoid sort of a trial within a trial, correct?
That is correct, Your Honor. The court does have that discretion. And our argument is that the court abused the discretion. And this is the reason why. The reason is because without any evidence, a scintilla of evidence, the court found that maybe MJ didn't understand the questions. Maybe he was confused. Maybe the officers didn't ask the correct questions, even though the state did not present one item, testimony, an affidavit from MJ, an affidavit from one of the officers, or anything corroborating those speculative claims. So what we had on the one hand was described conduct of MJ lying, and then later a plea to that conduct that he initially denied. And on the other hand, pure speculation, absolutely entirely pure speculation about some of the things the state said, like, oh, well, maybe he didn't understand the questions. And that's why we believe it was an abuse of discretion, because there was no evidence to reach those conclusions. And that, Your Honor, was not just an error, but a very prejudicial error, because MJ's credibility in this case was the entire case. It was everything. And then the state was allowed to present an incomplete picture of who MJ was.
Counsel, let me ask you, you've talked about the credibility side of things. Let me ask you to move to the 404B argument that the parties address in their briefs as well.
Thank you, Your Honor. So, and then we mentioned in our brief that this is in part what's sort of irreconcilable here. So we had this conduct for the prior lies that was, not disputed by any evidence, that didn't get to make it in. But then we had mountains of evidence of this other 404B conduct. So this trial, as we mentioned, involved 5 days of presentation of evidence. So on the first day, the state called MJ to testify. That was on the first day. After he was done, the state called to the stand 10 witnesses to discuss evidence of other disciplinary spankings not involving MJ and not involving sexual molestation that were aimed at inflaming the passions of the jury. There were 10 witnesses over a 3-day period. And if the court will just indulge me for a moment, these are some of the things that the court heard, or I'm sorry, that the jury heard. Because, so our argument is that they shouldn't have been let in because they were not about sexual molestation, had nothing to do with MJ, but also because of the details that were brought up. So for example, Your Honor, during Linda Jolly's testimony, she said that she had confronted Tom about some, quote, severe bruising that was seen on a little boy named David Latner. Julie Welch, a different witness, said that Tom had knocked the wind out of me, that she couldn't even get a sound out. She talked about repeated hitting using a boat oar. She said that her brother's spanking was, quote, excessive, that her brother, quote, cried, that she saw that she saw DL get hit multiple times, that she was forced to watch some of this spanking. And then she kept referencing the boat oar. WW mentioned that DL was spanked, quote, countless times, quote, really hard, which would cause him to, quote, scream and cry. Richard Howe testified that Heather Eddles had made some allegations about DL, that he had been, quote, spanked excessively, that some of the spankings were, quote, getting out of control, quote, leaving bruises. Eric Owens, Your Honor, testified that he had learned that Tom was, quote, leaving bruises, even though he actually never saw any of these things. That had to do with DL, which is sort of a separate argument, but the same one. Caroline Sue Latner, Your Honor, said that she saw that DL could, quote, hardly walk or sit, that she saw, quote, bruises and blisters all the way down his thighs. She said that the, quote, wounds appear, quote, very fresh and, quote, very purple. Jessica Belling testimony. She said, and this is a little bit different but important, because in the first trial, when it was about DL, which was one of the other kids, when the state was trying to bring the evidence in, trial counsel specifically indicated that he didn't want people coming in here because DL was not testifying, saying that he didn't want to testify because he was traumatized or something along those lines. And the state's response was, if you do that, you can move for a mistrial. That was in the first trial. In the second trial, while Jessica Belling was, the detective was testifying, she said that she had one, quote, she was given word that he didn't want to talk about this, DL. She said that DL, she was given word that he didn't want to talk about it. And then after she was cross-examined by trial counsel, the prosecutor then asked the following question. As far as DL, you made attempts to speak to him? She said, yes. And the prosecutor's question, you understand that he was not in the right frame of mind to speak about this? That was the question that was posed to her. It was a clear inference that DL was so mentally traumatized that he couldn't talk about these things. And I just have two more witnesses. During Taylor Welch's testimony, she testified that JW was, quote, scared, that she was, quote, crying. She also made repeated references to a boat odor. And Pam Welch mentioned that JW and WW would be upset when she would pick them up from tutoring because DL was staying behind, and that DL was similarly very sad about staying behind. She also said that she learned about DL's bruises and that there were many other things witnessed involving DL. Now, all of the things I just mentioned, Your Honor, were not about MJ and did not involve sexual molestation. They were just pure disciplinary spankings, perhaps excessive disciplinary spankings, but not sexual molestation. And I'm only bringing to the court's attention some of the things because I can't bring them all. But that went on for 3 entire days after the first day in which MJ testified. So we just think that that was an enormous amount of prejudicial evidence that should not have been admitted under 404B.
Counsel, let me ask you to address specifically why you believe it wasn't admissible under 404B, because Mr. Chantry put intent or lack of intent at issue, correct?
Your Honor, at trial, Mr. Chantry didn't testify.
Let me tell you why I say that. There's a notice before the first trial, I don't think was ever changed, that said as defenses, lack of intent and no sexual interest. Those he put those at issue.
Okay, and then Your Honor, correct. And if those cases, Your Honor, had been those other disciplinary spankings had involved some kind of sexual conduct, perhaps I would say, oh, okay, they agree, but they were not. They were purely about spanking. So that's our argument as to the 404B, Your Honor. There are a number of other issues that we raised. I'd like to know if the court has any particular ones it wants me to address, considering the time.
Counsel, let me jump in on, you raised statute of limitations, but wouldn't you concede that it wasn't until 2015 or 2016 that MJ ever told anyone of the molestation? Wouldn't you concede that?
Your Honor, we do concede that. So our argument was twofold. One was under the mandatory reporting statute. And then number two, the kind of a broader argument that we're making is that, and it's perhaps novel, that MJ turned 18 more than a decade ago, right? So he just kind of waited, and MJ knew the identity of our client, Tom, and didn't do anything. So our argument is that it's unconstitutional. It's an unconstitutional deprivation of a person's ability to defend themselves at trial, to have to defend claims where a person sits on those claims for over a decade after reaching adulthood, because the trial was actually about 20 years after the conduct. But let's say, you know, MJ was a minor, understood. So MJ reaches adulthood, then waits over a decade to bring these charges up. And I think our argument is that we believe that sets a very dangerous precedent. That sets a very dangerous precedent where a person can just sit on evidence or sit on accusations until all the potentially exculpatory evidence has dissipated and then bring the charges. But we do concede what Your Honor said, that was the first time that MJ brought this up to law enforcement directly.
Let me ask, thank you for that. Let me ask one other question on a different topic. Are you prepared to, if I were to ask a question on law of the case and from the first trial to the second trial, where you feel the court erred in applying law of the case specifically?
Yes, Your Honor. And that's a really good question, Your Honor, because that's kind of a cloud over many of the issues that we raised. So the law of the case doctrine was misapplied here because the facts and circumstances of the first trial were significantly different from those of the second one. So in the first trial, there were multiple victims, and some of these victims were some of the folks involving the 404B evidence, like WW and JW. There were allegations of spanking there. So that makes sense. I know that trial counsel objected to that, but from an appellate perspective, it makes sense. That was a case that was about spanking and involved all these other people. So it makes sense that the state can bring those things in. Here, however, that was all done. None of those people were involved here. The charges did not involve any charges of assault, which were the spankings or excessive disciplinary spankings. And as a result, we believe that the change in those facts has to change the analysis with respect of, number one, whether to admit, for example, MJ's and truthful statements, because you go from having all this evidence as to all these charges to, in the second trial, the entire case hinging on the testimony and credibility of one person. So under the law, some of the times to not apply the law of the cases when some of the facts and law have changed. In this case, we think that all those things illustrate a change in facts that require the court to conduct a different analysis. And I see I have about 3 minutes of time remaining, and I'd like to save that for rebuttal.
Very well, and I have you at 3.5 minutes for rebuttal according to my clock. Ms. Ibarra.
Thank you, Your Honor. Eliza Ibarra for the state. I'd like to focus on what the court has just recently asked about, and then work my way backwards. The court asked about the law of the case, and I think it's important to realize that he didn't appeal from the first trial, but also the 404B issue was extensively briefed, specifically only in the context of the second trial. And the other two issues that he brought up under the law of the case, the 2014 indecent exposure incident, and also the expert witness issue, both of those involved the same topic. The expert testified, actually, I don't know exactly how the expert testified during the first trial because the first trial transcripts were not fully part of the record. But for purposes of the second trial, her testimony was incredibly brief and didn't rely in any way on the first trial. And okay, so the statute of limitations, like
Counsel, before you go to the statute of limitations argument, let me ask you one question on law of the case. Doesn't it really, I'm not sure where law of the case by itself takes us, because it seems to me that either the rulings pre-trial and at trial and post-trial for the second trial, either they were right or they weren't. I don't think, we're precluded from reviewing the substance of those based on law of the case. Do you view law of the case differently?
No, I would agree with that. I think the ultimate issue is whether the rulings were correct or not for the second trial, because he didn't appeal from the first trial. So I think maybe that's sort of a civil slant that may not be as applicable here.
Law of the case does come up far more often on this on the civil side. You're right. I interrupted your presentation.
Oh no. So for the statute of limitations, there's no dispute that the victim did not disclose until 2016, and police did not obtain the police report, or excuse me, the church investigation report, the 2000 report, until 2015. That's how they learned of his name. So there's no way that he could be outside of the statute of limitations because 7 years has not elapsed since even 2015. Moving on to the Rule 404B evidence. This issue was extensively briefed before the second trial. This court can affirm, in fact, is duty bound to affirm if the trial court's ruling was correct for any reason. I think I cited Butler, but also there's State versus Herrera, or State versus Boteo Flores, hundreds of cases out there that say that you don't waive a 404B reason for admission. All you need is something other than character, some purpose besides character for admitting the evidence. And if you have that, then it's admissible, as long as it's not outweighed by Rule 4043, or excuse me, by it's not outweighed by the danger of unfair prejudice under Rule 4043. And here, there were sort of three main reasons how Chantry attacked the victim's credibility, and opposing counsel has mentioned them. They accused him of fabricating it based on the delay. They argued that he should have also disclosed the abuse in his 2000 letter if it really happened. So they attacked him for his delay on that basis as well. And then they also argued that it was a defense if he wasn't sexually motivated to touch the victim. And so the three purposes that the state has offered in its answering brief directly go to each of those issues. First, they explained his delay in reporting due to the extreme physical abuse and spiritual and emotional threats to those he tutored. It also explained the cultural setting in which the victim grew up and the series of events that led him not to report this because his parents never took him seriously. And then during the 2000 church investigation, the parents were never encouraged to go to the police. They were just told, they were encouraged to forgive, and it was true that they were told that they could go to police if they wanted to, but they were told instead to forgive. And then, and so if you look at the issues, it would have been completely unfair to the state to not allow the state to explain the context of in which the letter was written. It was written specifically to, the victim was asked to address the spanking specifically. So that's one reason why he might not have mentioned the molestation. And also he was embarrassed and ashamed. And then finally, by putting his sexual motive in touching the victim at issue, Chantry disputed his motive and made it relevant that they were for a sexual purpose. And I think opposing counsel has said that he wouldn't have disputed them if the other children had been molested. But I think that the real question is whether the other acts provide a reasonable basis to infer the charged conduct. They don't have to be exactly the same. I think in the answering brief, I cited the case where the court appropriately admitted pornographic stories about incestuous conduct in a trial about the defendant's abuse of either his daughter or stepdaughter. And I think it's also important to remember that the witnesses that opposing counsel mentioned There weren't 11 witnesses who testified about the spankings. There were only 3 because the other witnesses had no personal knowledge. And it's true that there was a huge discussion about how the spanking was brought to the attention of Elder Howe and how he shared it with Elder Owens and how they were trying to decide what to do. And then Walt Chantry, Chantry's father, wrote the letter. And then they ultimately held the church investigation. And that was because during the first trial, I believe, Chantry always really disputed the church investigation. One of the witnesses, Pastor Lindblad, apparently even claimed that he'd been exonerated by the first trial, or excuse me, by the church investigation. And then after the investigation was over, this information was not admitted at trial, but it was brought out at sentencing. He ran around telling everybody that he had not had a fair opportunity to provide his story during the church investigation, and also that the elders just had it in for him. And so he fought tooth and nail about everything having to do with the church investigation. And so the state had to explain exactly how it was formed and why they were investigating these other spankings. And it wasn't just this random inquisition against Chantry.
Let me ask you, go ahead, Judge Williams.
Did this 404B evidence, I thought I may have misheard you, but did it go to show Chantry's motive or intent towards MJ's molestation?
Yes, I think that the fact that he spanked these other children for trivial reasons in an extreme and excessive way showed that he was spanking them for his own personal pleasure, and that made it more likely that he was spanking the victim for his own personal pleasure and also molesting him. So there is an inference. It's not a direct logic, but I believe that the inference is reasonable.
And you would agree that that there was no hint of any of those spankings for WW, JW, or DL leading to any type of fondling or rubbing or anything of the sort, correct?
There's definitely nothing in the record about the second trial that would suggest that. Yeah, I think that the fact that he did this to DL for 2 years, that makes it sort of suspicious, but there's no evidence that he molested DL.
Thank you.
And
Yes.
these incidents, pardon me, the 404B incidents with WW, JW, and DL all occurred after the time that's alleged that the offenses occurred here. Is that correct?
Correct.
And is that instructive under 404B that they occurred after?
No, I think I cited the case of Marino. That I definitely cited a case. I'm not 100% sure it was Marino. In my answering brief, that says that 404B incidents that happen after chronologically the charged incident are analyzed analytically the same as though they had happened before.
Okay.
And I think that's at the very beginning of my argument. In fact, here, I'll find it for sure. Let's see. Yes, it is Marino. It's on page 36 of my answering brief.
Thank you.
And if the court has no further questions about Rule 404B, I'd like to move on to the first issue, which is the 2014 indecent exposure incident. And I think the fundamental problem with it was that under Rule 608B, you can only inquire into it if this alleged incident of untruthfulness is actually probative of a witness's character for truthfulness or untruthfulness. And the 2014 incident didn't provide any discernible information about the victim's character either way. And the only way to analyze the issue would have been to hold an entire collateral mini trial. Because, and it's true that the state didn't put forth any witnesses or affidavits, but that was just because the police reports themselves were full of contradictions among the various witnesses and provided ample reason why the victim may have chosen to plead guilty, even if he wasn't the person who pulled his penis out in front of the girls at the park, because he admitted that his shorts were see-through and mesh. And if the court has no further questions, we would ask that you affirm.
I do have a question, a different topic. The motion in limine before the second trial that Chantry filed regarding the church cover-up.
Okay.
Is it fair to say that the church, in its investigation, had no knowledge of any molestation at the time while they did their investigation? There was nothing came out during the investigation other than spankings. Is that correct?
That is correct. I mean, I think if you read the victim's letter really carefully, he sort of hints that maybe something else is going on. But if you look at what they actually had before them, they did not have any information about molestation, just the physical abuse.
Okay. Thank you.
Any other questions for the state? Very well.
Okay.
Thank you, Ms. Ibarra. Mr. Barrientos, you have 3.5 minutes.
Thank you very much. I hear some sound. Hopefully you're not hearing it as well.
I think it's better now. Please proceed. Yes.
Okay, thanks, Your Honor. The first thing I'd like to mention is that with respect to the ruling on the 6-0 and the incident involving untruthfulness, there was no rehearing or rediscussion on that. It was just affirmed as law of the case. The second thing I want to mention, Your Honor, is that there was a lot of discussion from the state about motive here. And it's important that the court knows, as we mentioned in our opening brief and reply brief, that the trial court expressly precluded any mention of this evidence under 404C. In other words, the state could not use any of these things to allege that this somehow, evidence or illustrated some kind of sexual inherent conduct or something along those lines. And importantly, Judge Summer's question was really good. It's a good point. All these MJ's things related to MJ occurred in 1995. Everything else occurred in 2000. So how could one that occurred before be illustrative of the other sort of backwards? If anything, if there had been some of these other types of conduct in the spankings in 2000, then perhaps it would make sense, but that wasn't the case here. The third thing I'd like to mention before my time is up is that the court under State v. Rogers, which is 186 Aris 508, and State v. Mullen, which is 168 Aris 246, I like to mention the Supreme Court there said that the court shouldn't. I know that there is case law saying that you will affirm for any reason, but those cases explicitly mention that certainly when things are such fact involved, courts should be careful to affirm rulings on any reason in a criminal case. Let me see. The last thing I like to hone in on is sort of this unfairness. The state mentioned that it would have been unfair to bring in this impeachment evidence against the only witness with knowledge of the conduct that was accused, because it would have caused a mini trial. But where we really had a mini trial was on the spanking conduct. That went on for 3 days with 10 or 11 witnesses. So I think that there is an inherent unfairness in letting all this information in that didn't have anything to do with MJ or the type of conduct alleged in this case, and then prohibiting him from using the only perhaps evidence because of the passage of time and a number of other circumstances that he could use to have an effective defense. The defense to which he is entitled under our Constitution to cross-examine witness and to be have the ability to effectively cross-examine witnesses. So if I think we made an argument about prosecutorial misconduct, and we specifically would like the court to look at the Rule 15 violation because we are concerned. We think that that's a violation that was found after 9 witnesses had testified, an admission that the prosecutor didn't know how the rule operated and didn't know how many times she might have violated, specifically that rule as applied to disclosing the testimony of a prior witness to a prospective witness. And if the court has no questions, that's all I have.
Counsel, thank you for your presentation today. We appreciate it a great deal. Thank you also for your briefs. You spent an enormous amount of time, you and your colleagues, on this case, and we appreciate it. You've given us much to think about. We will take the matter under advisement and we'll issue a written ruling in due course. Court stands adjourned. Take good care.
Thank you.
Thank you.